Welcome to the 33rd meeting of the Justice Committee. We have no apologies this morning. Our first item of business is to agree to take item 8 in private. If we are all agreed, could you indicate accordingly?
Yep.
It looks like we are agreed, so we will take item 8 in private. Thank you. Agenda item 2 is to begin our stage 1 consideration of the Domestic Abuse Protection Scotland Bill, and I refer members to the relevant papers in our pack. And this morning we'll take evidence from the Scottish Government's Bill team, and I welcome to that end our first panel of witnesses this morning, who are all attending remotely. We have with us Patrick Down, Criminal Law and Practice Team Leader, Anne Cook, Head of Social Housing Services, and 2 solicitors from the Scottish Government Legal Directorate, Catherine McGarvey and Rachel Nicholson. Welcome to all of you to our meeting this morning. And I intend to allow up to an hour for questions this morning. But if witnesses wish to respond to each other's questions, as it were, then please use the Blue Jeans chat function to do so. Just press R in the chat box, and we will come to you. Do you want to make an opening statement before we get underway, or do you want to launch straight into questions? Patrick.
If committee members would find good morning. If committee members would find it helpful, I thought it'd be useful to give a very quick overview of what the bill does. As I'm sure you'll be aware, it contains 2 distinct topics. It provides for a new system of protective orders for people at risk of domestic abuse, and it provides landlords in the social rented sector with new powers to apply to a court, reassign a tenancy which is in the name of a perpetrator of domestic abuse to the victim of abuse. Turning first to the protective orders scheme, the bill provides for a power for the police to make an emergency domestic abuse protection notice, or DAPN, in cases where such a notice is necessary. They can make a notice if they have reasonable grounds for believing that the suspected perpetrator has engaged in behaviour which is abusive of the person at risk, that is necessary to make a domestic abuse protection order, or DAPO, for the purpose of protecting the person at risk from abusive behaviour by the suspected perpetrator. There's also a requirement that it's necessary to make the DAPN to protect the person at risk before a sheriff could make an interim or full DAPO. Where this last test is not met, police could decide to apply to the court for a DAPO without having first made a DAPN, and there would be the option for the sheriff to make an interim DAPO pending determination of that application. The bill provides an exhaustive list of conditions that can be included in a DAPN, which can be used to remove a suspected perpetrator from a home which they share with a person at risk and prohibit them from contacting or approaching them. Where the police make a DAPN, they must apply to the court for a DAPO on the first court day after the day on which the DAPN is given. The sheriff must then hold a hearing in relation to that application, not later than the first court day after the day on which the application is made. There is a requirement for that hearing to be concluded on the day on which it begins, but this does not preclude the sheriff from assigning further hearings in the proceedings. It is simply a means of ensuring that there's a clear point at which the DAPN ceases to have effect. It might be helpful if I very briefly outline the options open to the sheriff at that hearing. They can either grant the protective order, refuse the application, grant an interim order and set a date for a further hearing, or they could make no interim order but still set a date for a further hearing. The sheriff can make a DAPO if they're satisfied that the person against whom the order is sought has engaged in behaviour that is abusive of the person at risk, and that it is necessary to make the order for the purpose of protecting them from future abuse. The sheriff can impose any requirements or prohibitions which are necessary for the purpose of protecting the person at risk. And this order can run for a maximum of 2 months, capable of being extended on application to the court for 1 further month. This is in contrast with longer-term civil orders like non-harassment orders and exclusion orders, and reflects the fact that these are intended to be a short-term emergency measure. Breach of a DAPO is a criminal offence, punishable on conviction on indictment with a sentence of up to 5 years imprisonment and a fine. Briefly, Part 2 of the bill creates a new ground on which a landlord can apply to a court to end the tenancy of a perpetrator of domestic abuse with a view to transferring it to a victim of abuse. It applies where the perpetrator is a Scottish secure tenant and the victim is either married to or in a civil partnership with or cohabiting with the tenant, and will make it easier for a local authority or registered social landlord to transfer a tenancy to a victim of domestic abuse. These provisions could help to provide immediate and longer-term housing outcomes of domestic abuse, to improve the immediate and longer-term housing outcomes of domestic abuse victims living in shared social housing who wish to continue living in that family home, including by helping to avoid homelessness. We will now be happy to take questions from committee members. It might be helpful if I add that myself and Katie McGarvey lead on the domestic abuse protection orders side of the bill, and it's Anne Cook and Rachel Nicholson on the social rented tenancy provisions. Thank you.
Thank you, Patrick. That is very helpful, especially the last comments, which enable all of the members of the committee to know to whom they should direct their questions. So perhaps you can pick up this first question from me, which is about domestic abuse protection notices. The committee has received a range of written evidence about this aspect of the bill, and a range of organisations are indeed supportive of what is outlined there, but there have been quite serious reservations expressed by the Sheriffs Association, the Summary Sheriffs Association and the Law Society of Scotland, who have raised concerns about the concept of this domestic abuse protection notice, and in particular the test which must be met under the relevant section of the bill before a notice can be imposed, which, as I understand it, is simply that a senior police officer has reasonable grounds of suspicion. In this regard, what sort of level of evidence must be available to the police before they can issue such a notice? And can you assure the committee that the operation of this test will be compatible with relevant convention rights?
Thank you. I might first just clarify that the test is that the police officer approving the order must have reasonable grounds to believe that the suspected perpetrator has engaged in behaviour that is abusive of the person at risk, and that it's necessary to make the order. I make this distinction only because we think that reasonable grounds to believe is actually a slightly stricter test than reasonable grounds to suspect. Obviously, the police, like all public authorities, are obliged to act in compliance with the European Convention on Human Rights. I wouldn't like to try to give an exhaustive set of examples of what would or would not constitute reasonable grounds to believe in any given case. However, I'd note that, as I say, reasonable grounds to suspect is, I think, the test that the police would use in deciding whether they can arrest somebody on suspicion of committing an offence. So we are talking about similar sort of circumstances in that it could be a report that they have received about abuse. There could be eyewitnesses. It could be that the person reporting the abuse has previously complained of abuse on other occasions. I'm just going to invite my colleague Katie McGarvey if there's anything she'd want to add on this.
Thank you. Yes, in relation to reasonable grounds for believing, what I would say is I would agree with what Patrick said, that a question of belief is a slightly higher threshold than suspecting, and it's essentially a matter of degree, but the test, reasonable grounds for believing, is slightly higher than that, where there would be reasonable grounds for suspecting. And what I would say about the test as well is that there are essentially two elements to the test. So the constable, the senior constable who is making the decision, has to hold a genuine belief themselves, and also there have to be reasonable grounds for that belief. And the reasonable grounds part imports an element of objectivity into the test. And that's important because it means that the officer imposing the notice cannot simply act on their own subjective belief, but that they have to have grounds which can essentially hold up to scrutiny. And So that's an explanation of the test. And you've asked about ensuring that the notices are compliant with convention rights. We would acknowledge that, of course, there's engagement of Article 6 of the European Convention on Human Rights here, and certainly an officer in making a decision to impose a domestic abuse protection notice is not acting as a court of law, but convention jurisprudence recognises that in some exceptional circumstances where the object of any given measure requires efficient and quick decision making, in some occasions not all of the protections of Article 6 can be afforded in that time frame where the objective might be undermined. And in this case, the objective of these measures are immediate and enforceable protection for the person at risk, hence the ability of the police to impose a domestic abuse protection notice. But I would echo what Patrick has said, that reasonable grounds for believing is a test which would be commonly employed by the police, and also, as I mentioned earlier, contains an objective element to that test, which is important.
Thank you. Thank you for clarifying that we're talking about reasonable grounds of belief that, rather than reasonable grounds of suspicion. That's helpful. Can I ask, what is a police officer supposed to do in the event that she believes that allegations have been maliciously made? How would a police officer know whether or not the allegations that it's necessary to serve a domestic abuse protection notice have been made in good faith or maliciously?
Thank you. I think the observation I would make is that clearly this is something which the police inevitably encounter at the moment when they receive reports of allegations of domestic abuse. So when they attend a domestic abuse incident, it's something that they would have to consider whether there is sufficient evidence that a criminal offence may have been committed. And there will be occasions when, for whatever reason, they're not persuaded that that's the case. And I don't think that the fact that they now have the option of making a domestic abuse protection notice changes that. Clearly, the police at the moment will go to domestic abuse incidents where they will receive allegations and counter-allegations, where they might have two individuals who both claim to have been the victim rather than the perpetrator of any criminal offence of domestic abuse. And I think that will continue to be the case with under this new scheme. Obviously, in any given case, they would have to decide whether there is reasonable grounds to believe that either of those individuals has been subjected to abusive behaviour, and that it would be necessary to make such a notice to protect them from domestic abuse.
Finney wants to pick up this line of questioning, so can we move to John, please?
Thank you, convener. Good morning, panel. Yes, Mr. Down, very interested in this particular line, and what I wanted to know, not least as a former police officer, how this would work in practice. Sorry, convener, I should declare at the outset that I'm a member of the First Party Group in Men's Violence Against Women and Girls involved with the White Ribbon campaign. I'm trying to imagine a situation, Mr. Down, where in a landward part of the extensive region I represent, Highlands and Islands, an officer or officers are called to a location. You touched on this, your counter-allegation. What actually is going to happen? So these officers have reasonable grounds to believe that someone's at risk here. The individual gets arrested. What's different than what happens at the moment, please?
Another option that the police have, I'm aware that in the police's evidence, they outline the various means by which provision can be put in place to protect a person at risk where they've been charged with a criminal offence. But if in any given case the police decide that while they suspect that a criminal offence may have been committed, they are not persuaded that there's sufficient evidence to charge an offence, or for that matter, where in a case where the police initially do charge and report to the Crown Office, and later on in the process, the Crown decide to mark the case for no further proceedings, but the police believe that a person is still at risk and that there are reasonable grounds to suspect that the suspected perpetrator has committed domestic abuse against them, then they would have the option of making a protective notice to ensure that protection is put in place for the person at risk.
Okay, thank you. And that suggests a civil degree of proof rather than a criminal degree of proof, which would follow on from someone being arrested. Is that correct?
Yeah, I think that's our understanding of the test. I'll give Katie McGarvey an opportunity to come in.
Thank you. Yes, that's correct. The orders are civil orders. The civil standard of proof, which is the balance of probabilities.
Oh, okay. Again, thank you for that. I'm still trying to understand what happens on the ground. Officers attend at the scene. The suggestion is that this is an additional string to the bow to deal with domestic violence, which everyone would applaud on one level. In the instance of where there's reasonable grounds to believe that an accusation and indeed a counter-accusation have some credibility about them, and bearing in mind that there won't be it's unlikely an inspector will be in attendance, what's the time frame for all this decision making? Because it's all very well for us to sit and look at how it looks on paper. I'm very interested in how it will work in practice. So what time frame are we talking about, please?
I think that will inevitably depend on exactly how the Police Scotland choose to make use of these powers and the mechanism they put in place for enabling officers on the ground where they suspect that domestic abuse has occurred and where they believe that a protective notice, a protective order would be appropriate, or the mechanism they then have for clearing that decision with an inspector, because that's the level that the decision requires to be made at. I would note that similar powers have existed in England and Wales for about 6 years now, and they have domestic violence protection notices and orders, and that those are made in quite considerable numbers each year. But the bill provides a certain degree of flexibility as to the exact mechanism that the police put in place for decision making about these, provided that, of course, the decision is made by somebody at inspector level or above.
Okay, thank you. I have further questions. I think there remain some operational challenges connected with this. Thank you, Convener.
Thank you very much, John. I think that's a very helpful line of questioning that we'll want to take up with other witnesses in later panels as well. Can I just ask Patrick, before I move to Fulton McGregor in a minute, can I just ask Patrick and Katie, what happens if someone who's made the subject of a domestic abuse protection notice is on home detention release or is wearing an electronic tag that requires them to remain at home? Does the DAPN have the authority to release the individual from the requirements of wearing an electronic tag or being in a certain place at a certain time? How does this interact with other elements of the criminal justice system that we've already got in place?
Thank you. I have to admit, I think that's something that might have to come back to the committee in writing on, unless Katie McGarvey wants to come in. Of course, it would be a matter that the police would be able to consider in deciding whether to make a DAPN.
Thank you, Patrick. I think this probably would be something that would be worth coming back to the committee in writing on. However, what I would say at this stage is that I would agree with Patrick that this is likely to be something that the police would take into consideration when deciding whether to impose a notice in the first place, and it may not be considered appropriate to impose a notice given that the person would be required to stay within their home. It seems that it might not be appropriate to impose a notice in that case, but I think that this is an issue that would be worth us writing to the committee on.
Say that the committee is taking evidence on this bill from a range of external stakeholders a week today, and we would like to have your written submissions on these issues before then, so that we can put those points to stakeholders, which will be, I think, our last opportunity to do so, because of the timetable that we're working to, which is to meet the government's legislative ambitions. So could you turn that around ASAP? We'd be very grateful. Thank you. And with that, I'll hand over to Fulton, and after Fulton, it will be Shona Robertson, please. But Fulton first.
Thanks, Convener, and good morning, panel. It's on the similar line of questioning to where John Finney was at, and in terms of decision making. The Police of Scotland have suggested to the committee that if the police can issue a DAPN without the usual multi-agency involvement in decision making, this may not be a positive feature of the bill. Can you let me know what the government think of these concerns, if they're valid, and what proposals might be in place to address them?
The point I would make is that the bill does not specify the decision-making process that the police must follow. So if the police are of the view that the most appropriate mechanism for deciding in any given case whether to make a DAPN or not to do so is to go through a more multi-agency decision-making process and take account of the views of, for example, third sector support groups or local authority social work, the bill does not prevent them from doing this. However, it gives them the flexibility to be able to make a protective notice in an emergency situation without having had to first go through that multi-agency decision-making process if they consider in any given case that the need for speed outweighs any need for making decisions on a multi-agency basis. Because while there will be cases where the suspected perpetrator and the person at risk may be very well known to the police and to other agencies, there may be some where they are called to an incident and consider that the person may be at quite serious risk of abuse, and the need to put measures in place instantly might outweigh, in any given case, the need to take the views of other agency partners. I don't think there's anything in this bill that seeks to undermine the idea that the police would work on a multi-agency basis in domestic abuse cases.
I do understand the need for flexibility there. I think the situations you describe, allude to that quite well. But if the police are saying it's a wee bit of a concern in the bill, do you not have any, concerns yourself that that the police basically deciding whether they deal with the notice themselves or they go down a multi-agency approach? Is there not something that could be done with that? That would still allow the flexibility. Some guidance perhaps in place about when it would be a police decision. What matters might need to be around for it to be a multi-agency decision. It just strikes me, if the police are concerned about this aspect of the bill themselves, it's definitely worth looking at.
Yeah, certainly you might want to I'll think about. I think that this is certainly an operational matter that we might want to consider in quite some detail if the bill is passed, when it's being implemented, in terms of working closely with the police and other relevant parties to agree as full a sort of process for how these protective notices and orders, the legislation, will be used in practice. But I don't know that it's something, and obviously this is a question you might want to put to the Cabinet Secretary when he gives evidence, but I don't know that it's necessarily something that it will be helpful to specify in great detail on the face of the legislation, not least because in doing so, there is perhaps the risk that you lose that flexibility and there's less scope to adjust processes, reflect on lessons learned and improve them in the light of experience once the protective notice and order scheme is in effect.
Yeah, thanks for that. That was really helpful, Patrick. Thanks, Convener, that's me.
Thank you very much, Fulton. Rona Mackay wants to ask a supplementary on this, and after Rona, it will be Shona Robertson. But Rona first, please.
Thanks, Convener. Good morning, panel. Yes, it was just on that line of questioning. I'm just wondering if the police decided not to apply for a protection order and there was then a subsequent incidence of abuse, what would the victim have any recourse, for that? What would the outcome of that be, do you think, in terms of, what happened?
Clearly, in any case, as is the case at the moment, where the police could attend an incident that's reported to them, and they may decide either to arrest the suspected perpetrator or not on the basis of the evidence available to them. In any given case, it's possible that where a decision is made not to arrest, there may be a subsequent report, at which point the police may decide to arrest. And I think that the same is true here, that if in any given incident the police decide not to make a protective notice or to apply to the courts for protective order, if a further incident occurs, they may wish to revisit that decision.
Okay, thank you. Thank you.
Thank you, Rona. I'd like to move to Shona Robertson, please.
Thank you, Convener. Good morning, everyone. Under the bill, as you know, a DAPN can last for as little as 2 days, depending on where the weekend or any public holiday falls, and the process is set out in the bill. A DAPN must last until a decision is reached by the court on the imposition of a DAPO or an interim DAPO. Now, you'll be aware of the arguments around this. There is one argument that 2 days is insufficient to enable a case for a court order to be prepared. Also, conversely, if a DAPN typically lasts much longer in practice due to, for example, the pressure of court business, there is another argument that appeals rights against such notices might need to be built into the process for the benefit of the suspected perpetrator. So I really would want comments on either of those views and whether you think there is merit in any of the concerns being raised on both sides of the argument. And I think Patrick would probably be the best person to respond to that.
Thank you. I think I would note that I think I accept all those arguments. There is inevitably a trade-off and a balance to be struck between, on the one hand, ensuring that any decision made by police officer to bar somebody who has not necessarily been charged with any criminal offence from what could be their own home is subject to review by a court within a reasonable time period. And on the other hand, building into the process enough time for that decision, for that case to be prepared by the police for a decision by the court. I would note that the approach we've taken in the bill and to attempt to sort of strike this balance is to explicitly provide a power for the court to make an interim order in a case where they might decide that further evidence or investigation is required before they make a decision on the full order, and that interim order can run for up to 3 weeks. So there is power for, as a result, there's early oversight by the court of the police's initial decision, while at the same time, in cases where it's necessary, there is scope for more time to be allowed by the sheriff for further evidence to be prepared before a final decision is made on whether to grant the order.
So on that basis, obviously you consider the balance to be about right, but do you think then there'll be quite a high level of usage of those interim orders for that reason? Do you think that's something that we would see in practice?
It's certainly quite possible. I did speak to, when we were preparing this legislation, I spoke to colleagues in police forces in England and Wales. And I know that there they say that the decisions on the final order are usually made at the first hearing, but it's possible that a different approach may be taken here. It may be that sheriff courts prefer to rely more on interim orders.
Okay, thank you very much for that. That's all from me, convener. Thank you.
Thank you, Shona. And I move back to Rona Mackay, please, to pick up questions on protection orders. Rona.
Thanks, convener. Yes, just sort of following on a bit from Shona's line of questioning. How do you respond to organisations who say that the proposed maximum time for a DAPO of 3 months is too short? Maybe Patrick and
Thank you.
Katie.
It's yet another, I feel like I could be repeating myself here, is yet another issue where I think it's fair to say that there is a balance to be struck between, on the one hand, protecting the rights of a suspected perpetrator who may have been barred from what is their own home, and on the other hand, providing the person at risk with sufficient time to address their longer-term safety. I would note that where the person at risk, for example, wants to take out an interdict, non-harassment order or exclusion order, while there may be cases where a final decision, particularly on an exclusion order, might not be made within 2 or 3 months, in those cases I would expect that it's worth noting the courts have a power to make an interim order. So I would expect that in the great majority of cases, 2 to 3 months should be sufficient for the person at risk to have taken steps to address their longer term situation and safety.
Thank you, Patrick. Thank you. Just, I mean, due to the fact that it's relatively short term, it does mean that the other system of civil protection orders and the quite complex, other recourses will remain. Do you think that would mean that the reform of the wider system of civil protective orders for domestic abuse might have to be considered in the next parliamentary session? And one other thing that I really want to ask you is, would the bill would it extend to allegations of stalking from the victim? Would this bill cover the victim in that respect? Could it be applied for in that respect?
Thank you. To answer the second question first, this bill is restricted to cases where the suspected perpetrator and the person at risk are either partners or ex-partners. So it would only cover stalking where it's being carried out by presumably an ex-partner. I don't think it's meaningful to talk about stalking by a current partner, but if it is, then the bill would cover that.
Yeah, but sorry, just to clarify, it would cover that. It would cover it.
Or ex-partner, yes. Insofar as stalking is a form of abuse.
But not an abuser who's living in the home and leaves temporarily or whatever. Could that be issued then if a protection order is taken out against this person and he continues to stalk? Would this be enough to create an offence?
Yes, if you have a suspected perpetrator who is ordered to leave the home and then they carry on stalking by sending unwanted or abusive communications, telephoning, there's a power in this bill to make provision prohibiting them from doing that, and breach of any provision of a domestic abuse protection order is a criminal offence. So yes.
Yes, thank you.
And to come back to your question about wider system of civil protective orders, I'm just going to check my notes on this. Civil law colleagues have provided me with information in a moment. Right, on the downside of doing this all from home on Tiny print. Sorry, I can't find the information to hand.
You could come back to it
I am
when
aware
you're
that
writing.
the Scottish, the Scottish
Yeah, you
Law
could-
Commission are undertaking a wider review of civil protective orders, so it could well form part of work in the next Parliament. But I've already committed to come back to you on one point already, and we can certainly add more information about that question about civil protective orders as well. Thank you.
Brilliant. Okay, thank you. If I could just move on now to a different subject, it's with regard to consent from the victim. The call for evidence, 28% of respondents said that they thought consent should be required, but 46% didn't think it was necessary. Scottish Women's Aid feel very strongly that the victim should be asked to consent. And you know, this relates to the situation then being the victim not having control, etc., if they're not asked to consent. Can I have your view on that, and you know, on the whole question of consent? Can you tell me what your view on that is?
Yes, thanks. I think it's fair to say that in the vast majority of cases, these protective notices and protective orders are far more likely to be effective if the person at risk supports and consents to their being made, because clearly if they impose conditions on a suspected perpetrator, that's only likely to be effective if the person at risk both feels comfortable reporting any breach to the police and wishes to report any breach to the police. However, there could be exceptional cases where the police either believe that the person at risk does actually want an order being made, but is not wanting to be seen to be consenting because of fear of how the suspected perpetrator may react to that, or where the degree of coercive control being exerted is so great that the person at risk may not appreciate the level of danger that they're in, that we think there is a case for not making it an absolute requirement for consent in all cases. However, I accept, I think, that particularly perhaps with the orders as opposed to the notice, this is a very finely balanced case where an argument could certainly be made either way.
Okay, thank you. Thank you for that. Thank you, Convener.
Thank you very much, Rona. I think Liam Kerr wants to pick up this line of questioning. Liam.
Yeah, thank you, Convener. Good morning, panel. Very briefly, Patrick, it's just one question. It's on a similar sort of line, actually. The majority of respondents to the consultation thought that when a notice or an order is made, the person at risk should be referred to support services. But the Scottish Government hasn't taken that forward. For what reason?
Thanks. I would say that this is more about whether it should be placed in the legislation as a statutory duty or left as an operational matter for the police in each individual case. Certainly, I would expect that just as the police, when responding to a domestic abuse incident at present, would routinely refer the complainer in that case, provide information on how to, on how to seek help from an appropriate third sector support body. I would expect that they would do exactly the same when they're making a domestic abuse protection notice or applying for a domestic abuse protection order. The question, therefore, is whether it's appropriate to place a statutory duty on them to refer in every case, bearing in mind that there could be exceptional cases where the person at risk does not want to be referred, and there are potentially data protection issues in passing that information to a third party without the agreement of the person at risk. So we think it's best left as an operational matter for the police in individual cases. And we've not seen any evidence that the police are failing to make complainants in criminal domestic abuse cases aware of the support that's available to them. And I think equally, I'd expect that this would continue in a case where they're making a protective notice or order.
You done?
Yep.
Okay, I think Liam MacArthur wants to ask a supplementary on that, and then after Liam, it will be Annabel Ewing, please. Liam.
Thanks, Convener, and good morning, panel. Just following up Liam Kerr's line of questioning there. I can absolutely understand the reticence about putting this in a statutory provision, particularly if there isn't a great deal of evidence of police not acting in the way suggested. But I do wonder whether or not there may be a case for some form of presumption where, at least where a referral wasn't made, there'd be a requirement to explain the rationale or whatever. So in a sense, it provides some check. Notwithstanding, I think, the reassurances you've tried to provide the committee with, Patrick, that, as I say, there isn't a great deal of evidence that this isn't happening as a matter of course.
Yeah, that might be, in terms of amending the bill in that way, that might be a question that you could put to the Cabinet Secretary when he gives evidence in January.
I'm sure he'll be very grateful for that. Thank you very much. Annabel Ewing's going to pick up the line of questioning now. Then after Annabel, it will be Rhoda Grant, please. Annabel.
Thank you, Convener. Good morning to our panel. Looking specifically at the scope of the bill as far as the notices are concerned, if we look at the issue of who can be the perpetrator in terms of the relationship with the victim, as the bill is framed, it would deal with, in effect, intimate relationships and not wider intrafamilial relationships. And I just wonder if perhaps Patrick could provide some clarity as to the rationale for this approach. Thank you.
Yeah, it's broadly in line with the approach that we took with the earlier Domestic Abuse Scotland Act 2018, and it's a recognition that intimate relationships can involve particular imbalances of power, and the form of abuse can be, with an intimate partner, the forms of coercive and controlling behaviour can be of a particular kind that we think merits taking a separate approach for domestic abuse. And there may be a case for looking in the longer term at whether there are other situations, for example, involving intrafamilial abuse, stalking by acquaintances or strangers, or abuse by, for example, people sharing a house in multiple occupation, that could be looked at in future legislation. But we think that the definition of abuse in the bill, which is quite closely modelled on the definition of domestic abuse in the 2018 Act, is sort of specifically designed around the kind of abuse that can occur in intimate personal relationships. And it's not necessarily, we find it's not necessarily a good idea to dilute the understanding of what domestic abuse is by providing a sort of general power that applies both in domestic abuse cases and in other cases where somebody could be experiencing harassment, abuse by family members, friends or acquaintances.
I thank Patrick for that clarification. I just wonder if he would also, and this is by way of a supplementary on this question, and then I've got one other separate question to ask, Convener, would, in his view, notwithstanding that would be the policy rationale, in his view, would there be any technical problems from a legal perspective, a drafting perspective, in trying to widen out beyond the broad approach of the 2018 Domestic Abuse Scotland Act?
I think if that's a question ultimately about whether amendments to this bill would be within scope, I'm not sure I feel qualified to comment on that. It's sort of a legal parliamentary question. I don't know if my colleague Katie McGarvey wants to comment on this, or whether it's really a matter for the Parliament themselves to decide what they think the scope of the bill is. But
sorry, Katie.
Thank you. I don't think that that's something that I can make a definitive statement on, I'm afraid. I think it would be a matter for the Parliament in terms of whether that's within the scope of the bill, but I'm afraid I can't say definitively whether it would or wouldn't be at this stage.
Thank you for that. I mean, that is an interesting point as well in terms of scope, but I was perhaps also thinking just in terms of the operational efficiency, if you like, of what is being proposed in the bill is it seems to me, and I'm hearing the debate we've already had this morning on some of the issues, that it is sort of justified on the basis of what it's trying to deal with. And if you were to seek to widen that too much, you may lose some of the justifications for what is being sought in terms of the bill. And I guess we'll return to that issue. The other area I wanted to look at was the issue of the age thresholds. So whilst the perpetrator is to be 18 or over, in order for one of these notices to orders to be issued, the victim, on the other hand, requires to be 16 or over. And I just wonder if Patrick or Katie could indicate why this approach was.
Yeah, sure. The reason that we have slightly different thresholds is that we didn't think it would be appropriate for this power to be used in effect to require the removal of somebody who is legally a child from their home. So we've set the limit on the suspected perpetrator at 18. However, we recognise that it's probably a very small number of 16 or 17-year-olds who may be living with an older partner who is abusive, where we think it is appropriate that the power should exist to make protection for them, provided they are 16 or older. Now, I expect it would only be a very small number of cases where this would come into play. And you might have the question, well, why set it at 16? Well, the minimum age for marriage is 16. I think it's quite unlikely you would find somebody who is aged under 16 living with a partner or ex-partner. But where they do, I think that at that point, there are other child protection measures, for example, relating to the power to refer to the children's reporter, that might be more appropriate in those cases.
Thank you. And just a matter of clarity, would the child protection angle then deal with a perpetrator who was between 16 and 18, potentially?
Potentially, yes. I mean, I would say with the caveat that I think the number of 16, 17-year-olds living together independently as partners is probably vanishingly small.
Okay, thank you for that. Thank you, Convener.
Thank you, Annabelle. Rhoda Grant is next. Then after Rhoda, it'll be Liam Kerr, please. Rhoda.
Thank you. The protective notice gives some protection with relation to children, but it doesn't take in any other people, for instance, family members and the like. Why was that decision taken? Because as we know, family members can be, I suppose, can be on the receiving end of domestic abuse if the abuser can't access the person that they would normally abuse.
Next, the protective notice, it's important to remember, is a very short-term notice that's not subject to any court oversight. So what it does is put in place a sort of minimum set of conditions that we think are necessary to protect the person at risk in the very short term before a court can consider whether to make a domestic abuse protection order or interim domestic abuse protection order. At that point, it would be open to the courts to impose any condition. It would have a power to impose any condition that's considered necessary to protect the person at risk from abuse. So in appropriate cases, that could, if the court considered it was both necessary and proportionate, include a condition not to approach or contact, for example, other members of the person at risk's family, friends or acquaintances of the person at risk, and the court might consider that appropriate in a case where it is known that that might be a course of action that the suspected perpetrator might otherwise pursue.
It's widely understood that the most dangerous point in a domestic abuse situation is when the relationship breaks up, and if a notice was put in place, that I fear could be a time where the whole situation is very volatile. is there thought being given to this? Is there an opportunity to change this to involve other family members in the short, given it's a very short period of time we're talking about?
Certainly, I think that if the committee were to recommend amending section, I think it is 5.1 of the bill, which provides the set of conditions that can be imposed on a domestic abuse in a domestic abuse protection notice, to widen out those powers, I'm sure that the Cabinet Secretary, Scottish Ministers, would be very interested to consider the committee's recommendations in that area.
Okay. With regard to other court orders that might be in place, for example, shared custody of children, access to children, would the notice and the order take precedence over those? Because we all know of cases where abusive partners have access to children, and indeed they use them to perpetrate abuse going forward. So when a notice or order is in place, would a victim of domestic abuse still have to hand over children to an abuser?
Yes, it's our understanding that the conditions imposed in any domestic abuse protection notice or protection order would override any pre-existing court order. Clearly, it would be in the interests of the person against whom the order is being made, if they want to maintain child contact, to make the court aware of the existence of that order at the point when the application for a DAPO is being considered by the court. And I think it would be then for the court to decide whether, in light of that, it was or was not proportionate to include conditions prohibiting the suspected perpetrator from contacting any children.
Okay, would that be the same case with the notice, given that the notice has not gone to court and it is a short-term intervention? Would that take precedence over custody or access arrangements that were already in place by the court? So could the police override a court decision in the short term with a notice?
Certainly, I'll give my colleague Katie McGarvey a chance to come in and contradict me if she thinks otherwise. But yes, I think the police domestic abuse protection notice would override any pre-existing court order for the relatively short period of time for which it's in effect.
Okay, I'm just waiting to see if Katie comes in to contradict you. I don't.
Yes, please. Not to contradict Patrick, but just to add a point of clarification that it is not so much that we're saying that a police notice or a domestic abuse protection order would overturn another court decision. It is simply the fact that the effect of a notice and the effect of an order is such that it places prohibitions on person A, which, if person A is in breach of those prohibitions, is subject to a criminal offence. So it's in effect, the fact is that there is nothing to prevent the police or courts imposing prohibitions against contacting a particular child, even if there is some form of contact order in place. And the effect of that is that the person, if they breach that notice or order, will be subject to a criminal offence. So that is the rationale behind why we say that, in effect, these notices and orders could take precedence, because essentially person A would not be able to have that contact while a notice or order is in place. But as was mentioned by Patrick, it would be open to parties to draw to the attention of the court any outstanding orders that they wanted the court to take into consideration before imposing a protective order.
Okay, can I just... Sorry, I'm coming back at myself slightly. Is there time, given that the... Given that the orders are time limited, is there time to allow a victim of domestic abuse to go back to the courts to change custody arrangements. I know it obviously allows time for harassment orders and the like to be taken out, but would the family courts be able to react in time to changes to custody if an order was in place? Okay.
That is, sorry, so a point we may have to come back to you in writing on.
That would be useful. And just, sorry, one final question. Given that both the notices and orders have regard to children and the risk to children, is there the opportunity for a child to have a notice or order taken out in their own right?
No, the bill is specifically limited to partners and ex-partners. So a domestic abuse protection notice can, for the purpose of protecting the person at risk, prohibit contact with children. Likewise, a domestic abuse protection order can, but they are orders that are made to protect a partner or ex-partner from the risk of abuse. So there wouldn't be a separate domestic abuse protection order taken out to protect a child, if that makes sense.
Yeah, it makes sense, but it doesn't recognise the damage to a child by domestic abuse. But I think that's a policy issue rather than an issue of fact.
Okay, thank you very much, Rhoda. Could I ask Liam Kerr to pick up the questioning on criminal offences next, please? Liam.
Of course, thank you, Convener. Yes, as the Convener says, I'd like to ask about the criminal offences when a notice or an order is breached. So I'm looking specifically at Section 7 and 16. Now, a breach of a notice or an order without a, quote, reasonable excuse would be a criminal offence. What's a reasonable excuse?
I think that would inevitably depend on the facts and circumstances of the particular case, but one of the conditions that can be imposed on a domestic abuse protection notice is not to contact or approach the person at risk. And there could be, in any given case, very exceptional circumstances where it might be necessary for them to contact the person at risk. I wouldn't like to speculate as to what they might be, but for example, where for whatever reason there were children who were in the custody of the suspected perpetrator, and I dare say that might be very unusual, and there was an emergency, then it's possible there could be reasons why it was necessary for the suspected perpetrator to contact the person at risk. Likewise, the bar on approaching is such that there could be very exceptional circumstances where, for whatever reason, perhaps they both happened by chance to be in the same place at the same time and didn't expect to be. It would be a matter for a court to decide in any given case whether there was a reasonable excuse for breach of the conditions, and I wouldn't like to try and exhaustively list the possible hypothetical examples where that could come up.
It feels rather subjective. Unlike perhaps the answer you gave, Convener, right at the start, saying that reasonable grounds were objective, that all feels rather subjective, and particularly when the criminal penalty is potentially quite severe. Which begs another question. You see, the breach of an order or a notice in England and Wales, I understand, is not a criminal offence. Why in Scotland are we proposing a different course of action?
It might be helpful if I clarify. In England and Wales, breach of a notice is not a criminal offence, but breach of an order is a criminal offence, and they too have this condition that it's an offence where it's done without reasonable excuse. I think there's actually a very similar provision in the equivalent law around breach of non-harassment orders and the conditions in those. I think it's a fairly standard approach. The reason why we've made breach of a domestic abuse protection notice a criminal offence is the alternative that they've taken in England and Wales is effectively to provide a power to the police to arrest the suspected perpetrator and hold them until a hearing can be held on the domestic abuse protection order. But the views that we had back from consultation respondents was they thought that that was a much less effective deterrent than making breach of a domestic abuse protection notice a criminal offence in itself.
Thank you. A final question from me is on a slightly different topic. It's actually section 8, wherein the police can apply for an order, but not other organisations or individuals. Now, responses to the consultation suggest it might be appropriate to widen that. And I believe, again, in England and Wales, they're proposing a wider category of people that could apply. Why did the Scottish Government not agree?
Essentially, it comes down to the fact that the police, as far as they're responsible for criminal investigations into domestic abuse, will often be the ones who will have the most substantive evidence that abuse has taken place. They'll be well used to tests in terms of sort of thresholds for, I mean, in the case of criminal offences, what amounts to what could potentially be sufficient grounds to take a criminal prosecution. They are also going to be aware of whether any criminal prosecution is ongoing. So there's not the same risk that any application for a protective order could override or conflict with in any way a criminal investigation. That's not to say that there's absolutely no case for potentially extending to other organisations, but on balance, we think that the best approach there is to encourage the police to work with those other organisations, like, for example, social work or third sector domestic abuse support organisations, to agree a protocol by which they can report concerns they might have to the police. So the police act almost as a kind of central point in deciding whether to make an application for a domestic abuse protection order.
Okay, thank you very much. Liam, is there anything else you wanted to ask on that?
No, thank you.
Okay, thank you very much. In that case, can we turn to John Finney to ask questions both about this aspect of the bill and also about the powers in relation to social landlords. So you might want to ask these questions to different members of our panel, Mr. Finney, but over to you.
Yeah, indeed, Convener, thank you very much. Initially, if I could direct a question to Mr. Down, please. Mr. Down, of course, there are existing protective powers, and the policy memorandum talks about the intention of this bill to complement but not replace. The existing non-harassment order can only keep a perpetrator away from a home they have already left, but it cannot remove them from a home they have a legal right to occupy. Now, under Section 8 of the bill, a civil court, but not a criminal court, can grant a EAPO. Can you explain why the Scottish Government is proposing to restrict the power of a civil court to grant an order? Would that not be a useful addition to criminal courts' powers, please?
We saw views on this in the consultation, and it's fair to say there were mixed views on whether it would be helpful to allow the courts to impose a DAPO on conviction. However, the views that we got back from those organisations who work most closely with victims of domestic abuse, and in particular Scottish Women's Aid, was that they were the view it wouldn't be helpful because there's sort of long-established precedent in their view that in criminal cases, non-harassment orders are widely used to keep a perpetrator away from a home. I suspect in practice because in a criminal domestic abuse case, the person, in this case, convicted person, I'll stop using the phrase suspected perpetrator, the perpetrator will probably already have left the home. And their view was that because of that, because there's a time limit on domestic abuse protection orders, it might actually reduce the use of non-harassment orders, which they consider would, in that context where the perpetrator has been convicted and has probably left the home, their preference was that non-harassment orders, where there isn't the same time limit, are actually the more effective route. And so it's for that reason we haven't provided a power for criminal courts to impose DAPOs.
Thank you. I wonder if the circumstances, Mr. Down, perhaps where someone appears from custody, would that be not an opportunity? The relationship between the civil and criminal courts is, and the levels of protection indeed provided to victims varies. But if someone were to appear from custody, surely that would be a worthwhile addition to the armoury of the sentencing judge in a criminal court.
Thank you. Can I check, if we're talking about appearing from custody, are we talking here about someone who is being held in custody at the point at which they're being sentenced, or the point at which, for example, a decision is being made about whether to grant bail pending a criminal trial? Can I check that?
Well, I was thinking of the circumstances where someone may have been arrested, and I appreciate it's perhaps less likely nowadays, kept in custody due to the likelihood to reoffend and appear in court the next lawful day.
Yeah, well, our view is that actually in that case, the powers that the police have to make a domestic abuse protection order at the point, for example, if the court were to decide to release them from custody, would be more appropriate. But actually, in any case, it would be open to the court to impose bail conditions that would prohibit them from contacting or approaching the complainer in that criminal case. So actually, in those cases, there are already powers that the police and courts have to keep to prevent a suspected perpetrator from approaching a complainer in a criminal case pending the trial.
Okay, thank you very much. That's maybe something I'll probe further with the Minister there. Convener, I have some questions, as you say, and these are on housing, and I would like to direct them to Ms Cook or Ms Nicholson. Firstly, perhaps to Ms Cook then, where the perpetrator is the sole tenant in a property and the person at risk is another occupier, Section 18 does not allow the court to authorise the transfer of the tenancy from the existing tenant to the person at risk, thereby making them the new tenant. After the court order is obtained, the social landlord must take the further legal step of creating a new tenancy for the person it wishes to remain in the property. Would it not have allowed for a more seamless process for the person at risk if the court itself had been able to order the transfer of the tenancy, please? Oh, sorry, Ms Cook, I'm not hearing you. Perhaps if you wait.
Sorry, is that better?
Thank you.
Sorry, it's from an iPad. The point is that the court cannot order transfer of tenancy. It is the landlord, the social housing landlord, who would then offer the resulting tenancy to the victim, because the contract is between the landlord and the person they're offering the tenancy to. So that's why we kept it like that it would be the landlord would then offer the tenancy, after the perpetrator has been ejected and a court decree has been obtained. I'm not sure whether Rachel might have a view on that, sorry.
Ms Nichols. Thank you.
Hi, good morning, committee. Yeah, I would simply add that one of the grounds as well in which must be met in order for the landlord to complete the process is that the victim survivor does wish to continue living in the property. So I don't know if that helps clarify the position there.
I'm trying to. Was this to not disenfranchise the landlord in relation to their rights? Is that the rationale behind it? Because it would seem to be seamless if the court could just do away with the resulting administration.
Could I talk, please? So I think we could perhaps revisit that and come back to you. But our understanding is that it's the landlord who has to offer the tenancy as it's a contract agreement between the landlord and tenant through the Scottish Secure Tenancy Agreement. Again, I'm not sure whether a court could actually set up a contract like that. Rachel, don't know.
Okay, thank you. Okay, well, we'll maybe hear back from you on that, and perhaps yes, also with regard to the issue of reasonableness, if you could maybe clarify some more information around that, please. If I may, my final question relates to Section 18 only covering social landlords. I wonder, can you advise what the government proposed for a person at risk who lives in a private home or some other form of dwelling that's not covered? In particular about the Gypsy Traveller community and the significant challenges associated with accommodation for them. Can you comment on that, please?
Yes, indeed. Sorry. At the moment, the provisions don't apply to the private sector at the moment, or indeed Gypsy Traveller communities. They only apply to tenants who have a Scottish secure tenancy, so that's RSLs and local authorities. This is all part of the work of the HARSAG group and the Chartered Institute of Housing and Women's Aid-led committee on looking at improving housing outcomes for people subject to domestic abuse. Their immediate work focused on the social housing sector. There's also been quite a campaign from the Chartered Institute of Housing and social landlords who were very keen to have these provisions so that they could be more proactive in supporting victims of domestic abuse who live in their tenancies. So that group will now be looking at the opportunities and the issues in the in the private rented sector, so that they give due consideration, consultation to see what protections could be applied in the social rented sector. And I think we have to think that the scale of the issue is so different. There are 185 social landlords and approximately, I think, 245,000 private sector landlords. So it's a much more difficult thing. So the decision was taken that this bill would cover the social housing side, but there will be work ongoing to look at what similar protections could be applied and provided in the private sector.
Thank you for that. Of course, the vile thing that is domestic violence doesn't know any social boundaries. It takes place in all social sectors. Was there any indication of a time frame for that work? We certainly wouldn't want to give the impression that your source of your accommodation related to the level of protection you were given.
Indeed, I mean, it's appreciated that domestic abuse happens across all sectors, including indeed the owner-occupied sector. My understanding that work on this is about to start shortly.
Okay, again, if you could give right to the committee with any further information of time frame, the scope of that work, please, and particularly with regard not only to those not covered that you mentioned in the private sector, but also the challenge of dealing with domestic violence in the Gypsy Traveller community, please.
I will do.
Thank you very much indeed, panel. Thank you, convener. That's me.
Thank you very much, John. Liam Kerr has a supplementary, and so do I, but Liam first.
Yeah, very brief question for me, something that occurs. A notice or order, I believe, will only have legal effect in Scotland, such that I could do something, if I was subject to this order, I could do something in England that was banned in Scotland but wouldn't constitute an offence. My understanding is that in the proposed England and Wales bill, any notices or orders would have cross-border legal effect. Could you explain why there's a difference, if my premise is correct?
Yeah, it might be helpful if I firstly just explain in a bit more detail the rules on jurisdiction. You're right in that it would not be an offence for somebody to breach an order while in England and Wales, or indeed outside the UK. However, the rules around jurisdiction are such that if somebody, for example, decides to travel across the border to England and start sending abusive messages or repeatedly phoning the person who's been protected by the order from another location, England, could be anywhere, the rules on jurisdiction are such that that is considered to be within the jurisdiction of Scotland, because it's based on where the person who's being protected by the order is at the time. In terms of whether it would be helpful as a matter of Scots law to provide that breach of protective order in England or Wales is an offence under Scots law, which, as I understand, is what's being done in the English bill. It's open to question. These are short-term orders. They apply for a maximum of 3 months. They are principally intended to in particular protect the person at risk in their home and remove a suspected perpetrator from their home. My understanding of the English and Welsh bill is that it's intended not only to replace their existing domestic violence protection orders, but also to act as a replacement for occupation orders and non-molestation orders, which are longer-term orders insofar as they relate to domestic abuse cases in England and Wales, and where those longer-term orders, there's perhaps a stronger case for having cross-UK jurisdiction, albeit I think it is worth noting that in order to get a warrant for the arrest of in order for the police to arrange for somebody to be arrested for breach outside Scotland, they would have to get a warrant from a court, and it might be potentially quite a difficult process for the police to act in terms of immediately acting on a breach of a protection order that occurs outside Scotland. But it's perhaps something that we could consider.
Thank you. I have a final question which I've been puzzling away at since the beginning of our conversation this morning. It goes back to the issue that we were talking about right at the beginning, which are the circumstances in which the police would want to make a domestic abuse protection notice. Given that in order for a domestic abuse protection notice to be lawfully made, a senior constable has reasonably to believe that a person has engaged in behaviour which is abusive, such behaviour being a criminal offence under the Domestic Abuse Scotland Act. What are the circumstances in which the police would want to make a domestic abuse protection notice rather than arrest somebody for suspicion of breaching criminal offences which this Parliament passed into law a couple of years ago? I just don't quite know if I understand the relation between the notice-making provisions in this bill and the substantive criminal offences which already exist.
Couple of examples I think I would give. The first is that clearly these are civil orders, so the test is balance of probabilities, and there could be cases where the police reasonably believe somebody has, to be blunt, committed an offence of domestic abuse, but they know from the outset that for example, there is no corroborating evidence and no prospect of that, or that there's no realistic prospect of proving it beyond reasonable doubt. So they might decide in such a case that a domestic abuse protection notice is a more appropriate course of action. The other case could be where the police do, in fact, initially arrest and charge the suspected perpetrator with a criminal offence. They report it to the Crown Office for consideration and prosecution, and the Crown Office might later decide that there should be no further proceedings. They may decide that there's an insufficiency of evidence to bring a criminal prosecution, and the police may nonetheless believe that the test in this bill of reasonable grounds to believe that the suspected perpetrator has been abusive towards the person at risk, and that the making of a protection notice or application for protective order is necessary to protect them from future abuse has been met.
Yeah, it's interesting, isn't it, how in the bill we're talking about reasonable grounds for belief, but in criminal powers of arrest we're talking about reasonable grounds of suspicion, but in the bill we're only talking about a balance of probabilities, whereas in the criminal law we're talking about beyond reasonable doubt. So where the overall burden of proof and standard of proof sits in relation to these two procedures is not straightforward, is it?
Yeah, I'd just like to let my colleague Katie McGarvey come in at this point.
Thank you, Patrick. I just wanted to clarify something in relation to these orders and a distinction between the underlying behaviour that's required for imposing a notice and an order in comparison to the underlying behaviour that's required to constitute a criminal offence. Now, of course, as Patrick has said, these orders are civil orders. When they get to the court, it will be civil standard of proof and civil rules of evidence. When it's with the police, it will be reasonable grounds for believing. But over and above that, what I would point out is that these are preventative measures designed to prevent domestic abuse and to prevent further abuse. And what I would point out in that regard is that the definition of abusive behaviour and the behaviour that's required to impose a notice or an order is only required to be a single incident. So it can be a single incident or a course of conduct which forms the underlying behaviour. Of course, the police and the courts will also have to consider that it's necessary to impose a notice or order to prevent further abusive behaviour. But I would just draw out that distinction. In the domestic abuse offence in the 2018 Act, there's a requirement for a course of behaviour, whereas the underlying behaviour that can form part of a notice or order can be a single incident or a course of conduct.
Okay, thank you. That's helpful. Can I thank you all for your evidence this morning? And can I just say that you have said on 5 or 6 occasions during the course of the morning that you will write to the committee with further details on questions that we have asked of you. And can I just underscore the importance from the committee's perspective of doing that very quickly? We have only one opportunity to put these points to external stakeholders, and that opportunity is 1 week today. And then in our first evidence session back after the Christmas and New Year break, we'll be hearing from the Cabinet Secretary. So I'm afraid none of us has the luxury of time. So if we could hear from you with those details before we are able to put those points to external stakeholders next week, we'd be very grateful. And with that, I will suspend this meeting for 2 minutes just to enable a changeover of witnesses. Thank you. I think it's just trying to understand how it fits. Welcome back. For our next item of business, we'll take evidence from the Cabinet Secretary for Justice, Humza Yousaf, who joins us this morning, and his officials on the Covert Human Intelligence Sources Criminal Conduct Bill, which is a UK bill in respect of which the Scottish Government have published a legislative consent memorandum. So I welcome our witnesses today. The Cabinet Secretary is with us, and he's joined remotely by Graham Waugh and Douglas Kerr. And as usual, Cabinet Secretary will direct questions to you, but please feel free to bring in your officials as and when you want. So could I just open up by asking, well, first of all, if you've got any opening statements, and if you want in your opening statement just to update the committee on where exactly we are with regard to this bill and its passage through the UK Parliament, because as I understand it, we haven't yet quite reached the last amending stage, so it's still possible for the bill to be amended before this Parliament has to determine whether and if so how it wants to give consent.
Yes, and possible for a supplementary LCM to be provided at a later date as well. So thank you for the opportunity. To just update Parliament very briefly, and then of course I'll be happy to take questions. The Covert Human Intelligence Sources Bill was introduced in Westminster Parliament on the 24th of September. It aims to provide an express statutory power for certain public authorities to authorise a CHIS, a Covert Human Intelligence Source, to participate in criminal conduct where it's necessary and proportionate to do so. A CHIS can, of course, be vital in gathering essential intelligence, intelligence which may save lives. It may protect the public from very serious harm, including organised crime and child sexual exploitation. The bill, as it currently stands, we believe, presents, as the bill presents, it lacks, I think, insufficient safeguards. That could be greatly mitigated if prior approval by a judicial commissioner at IPCO was required before a CCA was made, a criminal conduct authority was made. As the bill has progressed, it's clear that there is cross-party concern around the sufficiency of the safeguards and potential human rights implications. Some of the additional safeguards that have been called for include, but are not limited to, setting out in the face of the bill certain conduct that cannot be authorised, limitations around granting CCAs in relation to juvenile CHIS, and the need to ensure that legitimate trade union and political activity, party political activity, are not subject of any criminal conduct authorisation. These are concerns that I also share, that have been articulated by a number of human rights organisations, including Reprieve and Amnesty International. I think the committee may have received some written briefing in that regard. The bill amends the Regulation of Investigative Powers Act 2000, RIPA, and also the Scottish RIPSA legislation as well. The amendments provide, as I say, for a new CCA, criminal conduct authorisation, which makes conduct lawful for all purposes under that authorisation. In relation to your direct question around legislative consent, in relation to that, to the LCM, amendments to RIPSA cover operational activity in Scotland by Police Scotland and the Scottish Administration. In practice, really, that means the Scottish Prison Service. Amendments to RIPA cover operational activity in Scotland by certain UK bodies, again, in particular the NCA and HMRC, where they grant an authorisation for the purposes of preventing or detecting crime or preventing disorder. The bill also amends the related oversight provisions in the Investigatory Powers Act 2016. I agree that it's sensible to put the matters of criminal conduct by a CHIS beyond any doubt for it to be properly regulated and subject to very strong safeguards. I would prefer a consistent Four Nations approach to this area. However, to legislate for someone, to allow someone to break the law is a serious matter, and any measure must be accompanied by appropriate stringent safeguards. My strong preference, which I should say is also consistent with the views of the Lord Advocate and the Chief Constable, is for there to be prior approval by a judicial commissioner at the Investigatory Powers Commissioner's Office, IPCO, before a CCA is made. That will provide an independent judicial assessment that the authorising officer has made a decision that is necessary and that is proportionate to what the authorisation aims to achieve. I've been pressing the UK Government for stronger oversight than currently exists in the bill. I accepted that in the absence of prior judicial approval, it would be acceptable for an amendment to be made requiring notification to IPCO immediately after the CCA is made, but that would be subject to the other concerns which I've mentioned being addressed. That is why I agreed for IPSA amendments to be included in the bill on introduction. There has been a good level of engagement with the UK Government, but despite assurances, no such amendments have been tabled. I'm aware that an amendment has been proposed in the Lords requiring notification to IPCO within 7 days. That hasn't been accepted as of the time of speaking, and my personal feeling is that 7-day period is frankly too long of a window. So at present I cannot recommend the Scottish Parliament should consent to the bill. As the bill has progressed, there are significant and in my view valid concerns from cross-party members in the House of Commons and indeed the House of Lords. They are set out in the LCM. If the UK Government can bring forward suitable amendments to the bill at House of Lords report stage, the Government will reconsider its position and will bring forward a supplementary LCM if necessary. To conclude, as I've made clear to the UK Government, the bill would need to be changed substantially with greater independent oversight and additional safeguards in relation to the human rights concerns that have been articulated before the Scottish Government can reconsider its position and recommend that the Scottish Parliament consents to the bill.
Thank you, Cabinet Secretary. That's very helpful. Could I just understand something of the nature of the use? Partly the nature of the use of covert human intelligence sources in Scotland at the moment, and really so that I can understand the scope of the legislative consent which is being sought by the UK Government and which is within the responsibility of this Parliament to decide whether to give or not. So most of the agencies that will be able to seek CCA under the bill are UK agencies that operate in reserved space rather than in devolved space. The striking exception to that is any police force. Obviously, Police Scotland is devolved. In addition to Police Scotland, who uses covert human intelligence sources in Scotland that fall within devolved competence? Are we only talking about, in terms of our conversation about legislative consent, are we only talking about Police Scotland or are we talking about others?
So you're absolutely right. Largely Police Scotland would be the ones that would be affected by this, as well as potentially the Scottish Prison Service for devolved purposes. There was a briefing that the Chief Constable helpfully gave to some members of the committee, and he went into some detail in relation to what sort of criminal activity that Police Scotland would look to disrupt in that regard. It ranged from drug trafficking, human trafficking, right the way through to child sexual exploitation. So we're talking about extremely serious matters. But as I made reference to in my comments too, there would be an impact, of course, if UK-wide bodies were also using CHIS in Scotland for purposes of detecting crime. Largely the National Crime Agency and HMRC that might be doing it obviously for issues around tax or fraud in relation to tax as well. But you're right, the biggest implication would be for Police Scotland.
Okay, thanks. The amendments to the bill that you indicated in your opening remarks just now you wanted to see made pertain principally, perhaps you can clarify, they pertain either principally or entirely to authorisations. Now, as I understand it, in the House of Lords, where this matter has been quite extensively debated, there has been really there's been some significant concern voiced by, for example, David Anderson, who's the former independent reviewer of counter-terrorism legislation, and his predecessor, Alec Carlisle, about the extent to which IPCO should be involved in pre-authorisation. So the Scottish Government seemed to be pushing for an amendment which previous independent reviewers of counter-terrorism legislation are saying would be inappropriate and perhaps even dangerous. Could you just explain that for me? Because you will know much more about that territory than I do.
Sure, and it's worth saying that I've got a lot of time and respect for, in particular, Lord Anderson. I don't know Lord Carlisle as well, but I have met with him in a previous role. But certainly Lord Anderson is somebody I've met on a number of occasions, and I don't dismiss his view in the slightest. But what I would say, and I reiterate this, I think I made this point in my opening remarks, that prior judicial approval, even if it isn't IPCO approval, but I think that would still be the preference, that prior judicial approval is not just my preference in the government, but the preference also of the Chief Constable and the Lord Advocate. And really important that when it comes to the operational partners who deal with CHIS and the authorisation of any criminal activity when it comes to Police Scotland, that their views are listened to in this regard. I should also say that notwithstanding the concerns that Lord Anderson and maybe Lord Carlisle, and forgive me, I haven't seen Lord Carlisle's contribution to this, if notwithstanding their concerns, it is fair to say on the other side of that, There are human rights organisations, some of which I've mentioned, some of which I think who have written to committee as well, who express a greater degree of oversight. And my feeling on this is that where the law is sanctioning criminal activity, which is what this bill aims to do in very narrow parameters, of course, but seeks to do, then additional oversight that is independent of the bodies who are the operational partners can only ever be a good thing. So we can have a debate about whether it's SIPCO or whether there's some other oversight that is important, but at this stage I'm convinced that there must be additional oversight because of the gravity of what we're being asked to do in this regard, and at the moment that hasn't been provided for.
Okay, so but that's helpful. But you're aware of the concerns that have been put by Lord Anderson and others, and you're open-minded about the detail of what that oversight, relatively open-minded about what the detail of that oversight might look like. But your point, nonetheless, is that there needs to be some form of, preferably judicial, preferably IPCO oversight in advance of these CCAs being granted.
Yes, and I should reference, sorry, two other points. I mean, the human rights organisations, I shouldn't throw them into one homogenous category, they're not, of course, but having spoken to a few of them, there are also some human rights organisations that believe, and I think Reprieve might fall into this territory, where they absolutely believe in prior judicial oversight, but they're not sure that IPCO is the right body to do that. On the other side, I've also, and I'm sure he wouldn't mind me mentioning, I've spoken to Sir Brian Levison, leads IPCO, and while he is absolutely adamant, and he would want me to state this on the record, that these are policy choices for government to make, that if IPCO were asked to do a prior approval scheme, then they could facilitate such a thing. I asked him, could they facilitate such a thing if it was a different regime in Scotland than it was in the rest of the UK, and he's confident again that IPCO could do that, but he is absolutely firm and adamant, and again I must stress this, that would be a policy decision for government and Parliament ultimately to decide on.
Okay, that's helpful. Thank you very much. Can I bring in Annabel Ewing to pick up the questioning from here, please? Annabel.
Thank you, Convener. Good morning to the Cabinet Secretary and his officials. Looking at the issue from the perspective that it may well be that there are no satisfactory changes accepted by the UK government to deal with the additional safeguards that the Scottish Government is seeking, what then would be the plan? Would that require legislation to be brought in Scotland, and what would be the timing of that? If so, what would happen next in those circumstances? Thank you.
So thank you to Annabel Ewing for those questions. They are obviously very pertinent questions, but some of them I'm afraid I'm not going to be able to answer, and I'll come to the reasons why in a second, because so much of what we choose to do will depend on the Court of Appeal's judgment. Again, I won't rehearse the background because you'll have a briefing on that, and you will have seen it in the LCM motion, or sorry, explanatory notes that I brought forward. But our belief is, and again this would be up to the court, but our belief is that a judgment on this case will be made towards the end of January and will be published at the earliest in February, and a lot of it would come down, a lot of what we do next would come down to what was in that judgment. So as a responsible government, as you'd imagine, as taking a kind of prudent approach to this, we'll obviously base our planning on what would be the kind of reasonable worst case scenario. So the reasonable worst case scenario could be that the judgment does affect what we do here in Scotland, does have an impact on what is contained within RIPSA, and the worst case scenario would be that there would be a kind of cliff edge scenario whereby, unless there was express statutory underpinning for the authorisation of criminal activity for a CHIS, then it would be unlawful. And for that, we are preparing internally for emergency legislation. I mentioned that we've had a briefing with a number of opposition members in that regard too. I should state from the offset that would not be my preference. My preference would of course be for an issue of such complexity and sensitivity that we should do this in normal time as opposed to as emergency legislation. But in that worst case scenario, which I think is an unlikely scenario, and I can expand on why I think it's unlikely later if anybody wishes, but in that unlikely, what I would deem an unlikely scenario, we are making preparations for emergency legislation. I think any emergency legislation would have to have some sort of sunset clause, so that we could bring forward legislation, I would hope, and again, as I say, in a normal time. But we'd obviously want to prevent the scenario that there was an impact on operations, police operations, and participating CHIS that are, as I say, not just disrupting crime, but frankly saving lives as well. So it's difficult to tell you exactly what the next steps will be, because a lot of it may well depend on the Court of Appeal judgment.
Yes, I understand that. Thank you, Cabinet Secretary, for that comprehensive answer. Thank you, Convener.
Could I just ask, thank you, Annabelle, could I just ask the Cabinet Secretary, is the Scottish Government a party in the case in the Court of Appeal?
No, it's my understanding we're not, but there's a concern that any judgment could have a read across to RIPSA and potentially what we do. And of course, any judgment then could make another challenge to the Scottish Government, or Scottish administration, as it's technically known, more likely. So, yeah, it just depends on them.
But there's no current intention to join that litigation as a third party.
No, there isn't. Maybe a clarity from Graham Walk, who's online. But I'm clear that the current case is not specifically targeted towards the Scottish Government, but the security services and the UK government. Would that be right, Graham?
That's correct.
Yeah.
Thank you for that clarification. Liam Kerr, please.
Thank you, Convener. Morning, Cabinet Secretary. Very briefly, you set out various amendments to the Convener earlier on that you would want to be seeing made. You've obviously had dialogue with the UK government. So, as far as you're aware, why has the UK government declined to accept your amendments?
It's a difficult question for me to answer. I mean, I should say from the offset, I've had good engagement from the UK government. The Minister, James Brokenshire, has engaged frequently. I think we're speaking again later this week, actually, but he's engaged, I think, in good spirit. He's often listened to my concerns, and I know his officials have also spoken to the Lord Advocate. Why they haven't accepted prior judicial oversight, I don't know. And in terms of the other concerns that were raised from members right across the House of Commons, particularly around the human rights concerns, there was not any significant movement from the UK government in that regard. I could only really guess the reasons why. I don't truthfully know, but I suppose they are in a very different position to this government. They have a majority, and therefore I suppose there's less of an incentive to necessarily accept amendments. But really, I couldn't answer for the UK government.
They have a majority in the House of Commons, but not in the House of Lords, where the bill currently is. Rhoda Grant and John Finney want to pick up questioning from here. So Rhoda first, please.
In your opening statement, you talked about some of the balances that have to be drawn between community safety and civil liberties. I wonder if there are concerns about the bill as it stands, about legal organisations such as trade unions and others. Does the bill as it stands provide that balance, or is that also a concern that you have?
So in short, it's a concern we also have. I wouldn't need to rehearse to any member here some of the concerns about previous undercover activity in relation to peaceful, legitimate protest groups, for example. And I know it's an issue Rhoda Grant will know particularly well, as one of our colleagues has often commented on this issue. So there are concerns we have. I think the rebuttal from the UK government would be that any authorisation would have to be proportionate and necessary. I think my concern and why I'm so adamant on judicial oversight is that proportionate and necessary judgment, I think, should be made by somebody that is not part of the organisation that is involved in the operation of a CHIS. So in short, the answer is yes, I have those concerns. I think if there was if we had to bring forward separate Scottish legislation, then that is an area I would like to examine further. I couldn't say entirely 100% at this moment whether or not, for example, an exemption of trade union activity, for example, would be within scope for this Parliament, but it's certainly a discussion that I would be very keen to have, and internally, I should say, in preparations for an emergency bill, it is something we're exploring.
Thank you.
Okay, thank you. John Finney, please.
Thank you, Convener. Good morning, Cabinet Secretary and panel. Convener, as in the previous instance, I should make a declaration. I'm a member of Amnesty International, who are one of the groups that have put in a collective briefing to us. And Cabinet Secretary, if I could quote from that, You're aware that the wish is to have limits placed on what can and can't take place. And I think to most people it would be seen as not unreasonable to suggest that torture, murder and sexual violence be included in these limits. And this submission we have from that group that you're familiar with is, and I quote here, without express limits at the authorising stage, we worried that even improved oversight would leave too great a scope for abuses. They go on to say, even if a requirement was introduced for criminal conduct authorisations to be approved by a judge or regulator, experience in the surveillance sector suggests that a voluntary system of this nature is wide open to abuse when conducted in secret. Notably, the Investigating Powers Commissioner, who you quoted earlier, has himself conceded that MI5 systematically kept vital information from him to falsely justify surveillance warrants, and suggested the agency is failing to reliably record the kinds of crime in which their agents become involved. So, regardless of how this pans out, what's your view in that situation? I think everyone would want to see judicial oversight. What's your view of activities like that?
So the issue of what might be described as non-permitted conduct, I think, is one that does require careful attention. You know, I spoke to Reprieve and a number of human rights organisations about their concerns in relation to this bill, and they often make the point, and it may well be in your briefing also, that non-permitted conduct is something that it can be found in legislation in America and in other parts of the world as well. So it's not a very unique provision that they're necessarily suggesting. I think the counter argument to that, which I've heard being made in the House of Commons by excuse me, the UK government, is that the Human Rights Act would allow a safeguard against that kind of conduct. I think I've got a couple of concerns in that regard. One, that's the same government that has instructed a review of the Human Rights Act, and therefore, you know, I think I would be concerned about the intentions and the strength of that safeguard, but the intentions of that review. But secondly, you know, there's a concern that if you have non-permitted conduct, so murder, torture, sexual violence not being permitted in the bill, could that be used as kind of quote-unquote a test, whereby criminal gangs would then test, or criminal organisations would test a CHIS to see if they are actually an undercover informant or not. But so we'd have to think about those issues carefully. We'd have to consider them carefully. But again, if it's able to be done in other countries, and there's not particular issues in relation to that, then I have to say I'm very attracted to and sympathise greatly with those who ask us to consider, if we have separate Scottish legislation, non-permitted conduct on the face of the bill.
Thank you. Of course, that's the UK government that's seeking to sanction crimes committed by the UK military abroad. And also it doesn't believe, in this quote, and this is from a parliamentary publication, doesn't believe the Human Rights Act applies to abuses committed by its agents. One of the signatories of this briefing is the Pat Finucane Centre. Mr. Finucane, as you know, was a human rights lawyer who was murdered by the UK state. The De Silva inquiry confirmed that. Prime Minister David Cameron very gracefully apologised for that. We know that there's not going to be an inquiry into that now. Members of the public still harbour grave concerns about the untimely deaths of Hilda Morell and Willie McRae, for instance. I would like to know from you, Cabinet Secretary, what is acceptable? You alluded to previous instances, and we know taking the identity of a dead baby, for instance, the collusion that went with that, and what individuals referred to as state-sanctioned rape. How can we get an assurance that the Scottish Government, in a willingness to understandably try and have cooperation on this issue, won't inadvertently sanction any of these issues?
Well, to give you an assurance, the fact that I've not recommended consent for the LCM hopefully goes some way to demonstrate that I have concerns about this very issue. My concerns, as I say, can be put into three broad categories. One is around prior judicial oversight. The second is about Lord Advocate's concerns around interference with his role as the independent head of prosecution of crime. And the third is exactly what Mr. Finney articulates, the human rights concerns, which again I think can probably be put into three brackets. One is around non-permitted conduct, which he's spoken to in to some degree. The safeguards around juvenile CHIS. I think we have to remember that in some cases, young people very rarely be used as CHIS, but there should be appropriate safeguards around that. And then the issue that Rhoda Grant raised, which was around legitimate political protest or trade union activity. So I give you an absolute assurance that the government takes those human rights concerns very seriously. I should also say, though, the Scottish Government absolutely understands that there will be some instances where CHIS will have to conduct criminal activity. That may be unavoidable. There was one example that I know Police Scotland gave, and they were comfortable for me to speak to it. By way of an example, where an undercover operative infiltrated a paedophile network, which culminated in the arrest of a man who planned to pay to rape a 5-year-old boy and a 6-year-old girl. When arrested, further evidence of his offending was identified from his computer. The male pleaded guilty and received 8 years in prison. Now, in order for that undercover operative to infiltrate that paedophile group and network, they had to infiltrate networks that, and without going into operational detail, that would otherwise be criminal to do so. So there will be times when I think we have to all accept that. I think John Finney, I'm sure, does with his background and knowledge of policing. There will be times when CHIS will have to commit criminal activity. What we have to ensure that we're comfortable with as a government and a parliament is that any state sanctioning of that has to be within the narrowest parameters and ensure that it has the appropriate safeguards in place.
Thank you for that, Cabinet Secretary. And of course, everyone would accept that, or a drugs gang and the person being illegally in possession of drugs, of course. Can I ask you one other issue, please, and that is the potential for the term used of outsourcing? Because with the question of rendition, which comes up, there we have a situation where airports in my region, Inverness and Wick, have been cited, and there's Prestwick's also been said in relation to this. The idea that some poor unfortunate individual is trussed up in the back of a plane, shackled to the floor of that plane, hooded, and someone believes that that's appropriate in relation to so-called national security. Is there any progress in that? Is that something that can be used as an example of what we don't want? Because it's unfortunate the UK government haven't approached or certainly declined to assist the Lord Advocate with his inquiries into that.
I can be very brief in saying that John Finney will know the Scottish Government's position, my own position, and that hasn't changed, that we believe extraordinary rendition is absolutely unacceptable. And I too share his frustration and disappointment that the UK Government haven't approached the US administration in relation to the getting the unredacted Senate report. There may be a willingness to do so now that there's a new administration potentially in charge, and I'll pick that conversation back up with the UK Government. And I probably shouldn't say much more because there continues to be a live investigation into these matters.
Okay, finally, if I may, Convener, you mentioned HMRC, you mentioned the National Crime Agency, Cabinet Secretary. It's also the British Transport Police, of whom there's no direct political oversight. Could they also be covered by this? They work on a cross-border basis?
Forgive me, I would have to look at the annex of the bill in terms of all of the organisations that are affected by it. I may ask Graham Walk or Douglas. Yeah, so my assumption would be that they would be covered by it, but I would just double check with my officials online that British Transport Police would be covered.
Yeah, I'm afraid I would also have to check the legislation, but I would be very surprised if BTP weren't included.
Okay, thank you very much indeed. That's me, Convener. Thank you.
Thank you very much, Mr. Finney. So, Cabinet Secretary, I'm a bit confused now about exactly what it is that you're seeking from the UK Government by way of amendment to this bill. So can I just try and pin it down with a little bit more precision? If there were an amendment that imposed a requirement for prior judicial authorisation, would that meet the concerns of the Scottish Government with regard to legislative consent, or would you in addition want further safeguards amended into the bill to meet some of the issues that you were just exploring with Mr Finney?
So again, and forgive me if there's a lack of clarity here, but it would be, the concerns are threefold. One is judicial oversight, and yes, if there was prior judicial oversight accepted by the UK Government, I would have to say that would go a long way in satisfying my concerns. I think that independence prior to any authorisation being given, as I say, would go a long way. And again, I would have to discuss with others, and I would also discuss with opposition members in this regard. But I would have to say it would go a long way in satisfying my concerns. However, I'm not the only one that has concerns in relation to this. The Lord Advocate would also have to be satisfied about his concerns, which again, he can speak for himself. But as of yet, and I spoke to him recently on this, they have not been satisfied. And the third would be the human rights concerns. But if there is prior judicial oversight, a lot of the human rights concerns, I think, can be addressed because of that additional level of oversight. So, yes, you're right to allude to the fact, I think, convener, as you were doing, that prior judicial oversight would be the most significant safeguard, I think, that could be brought forward. And if we are satisfied, if the government is satisfied, we could bring forward, as I've mentioned in my opening remarks, a supplementary LCM. But at this stage, I cannot recommend that the Parliament gives consent.
I understand that at this stage you're not recommending that the Parliament gives consent, but I'm just trying to understand on the basis of paragraph 24 of your legislative consent memorandum what exactly it is that you're asking for that position to be changed. But you've helped with it.
Yes, I should say also, sorry to interject, but I should say the UK Government really is in no doubt at all about the amendments that we'd like to see. This has been a conversation that's happened over a number of months, and prior judicial oversight, has not changed in that regard. Now, if there was significant amendments made to the human rights concerns, then potentially, we could look at whether it's prior judicial oversight or whether it's notification straight after a CCA is made. But that would be dependent on the other human rights concerns. So it's a balance. That's why I'm careful to say that it would go a long way in satisfying my concerns, but we'd have to look to see what the detail of any amendment is.
Your official, thank you very much. Your official Douglas Kerr has indicated on Blue Jeans that he wants to come in. So can I invite Douglas Kerr to come in at this point?
Thank you, Convener. It was actually about the BTP question. It was just to confirm that BTP would be included. It's a bit of, you need to compare the lists that are in the bill with the list of organisations that are listed in section 46.3 of RIPA, and that'll clarify which bodies are in scope.
Thank you very much. I think Liam Kerr has one final question.
Yeah, final question, Cabinet Secretary, just to help my understanding here. As I understand it, the concern is that the Court of Appeal ruling would leave a lacuna, a cliff edge of no statutory underpinning for a CHIS. The UK bill, at its core, presumably seeks to plug that lacuna. And you would have concerns that that UK bill doesn't cover all the bases, but you presumably concede it covers some of the bases, and that with further safeguards, especially around the judicial oversight, then that might become okay. So the question, I think, arises, why wouldn't the Scottish Parliament consent to the LCM and ultimately the bill to give a baseline statutory underpinning and then work to nuance it from there, rather than risking the cliff edge that you fear?
I think it would be that if we accepted or recommended an LCM and the bill passed in Westminster, getting changes to it would be extraordinarily difficult, if not nigh on impossible, and therefore you'd be asking us to recommend to Parliament to accept a bill that has some, I would describe it, some very fundamental flaws, and I won't rehearse them all here. You understand where my concerns are. The concerns of trade unions in Scotland, the concerns of many members of the opposition, human rights organisations, etc. Whereas actually I think what we can do is, if we get to that reasonable worst case scenario, which is the cliff edge, which again I think is hopefully unlikely, then we have a plan in place to deal with that, but one that doesn't compromise, I would say, some important human rights concerns that exist. So that is the approach that I think is the most sensible one. He is correct. Liam Kerr is correct in saying that, you know, if we accepted the LCM, the bill covered the entire UK, then if a Court of Appeal judgment said that you needed express statutory underpinning, that would be there. But simply because it would plug that potential gap in that potential hypothetical scenario doesn't mean it's a right route to take because of the serious underlying human rights concerns that exist.
You said, Cabinet Secretary, that the reasonable worst case scenario is unlikely in your view. Why do you think it's unlikely?
So probably a few reasons. You know, you should never really second guess a court judgment, but from all of the conversations I've had, including with some of the claimants in the case, some of the organisations that have been mentioned already, they also feel it's unlikely. I suppose if we looked at the original judgment of the case in the IPT, the Investigative Powers Tribunal, the decision was a split decision. It was a 3-2 decision. The decision that was those that found in favour of the UK government were the 3 judicial members. I know. So therefore, again, without second judging at all, you know, we wouldn't want to make a presumption which way the Court of Appeal judgment would go. But I suppose the second point is that, again, without preempting anything, I think it would be unlikely that members of the judiciary would create an operational cliff edge for operational partners, and they know well issues around CHIS and the importance of CHIS. I think it would be unlikely they would create that cliff edge. Now, again, I can't say it's not going to happen definitely and definitively, and if it does, we have a plan in place, but my hope is it would be unlikely, and that's not just my view, I should say, it is the view of some of the claimants in this case that I've also spoken to.
So even if the appeal is successful, the judiciary, the appeal court may well be crafting a judicial remedy which is capable of achieving a result without creating a cliff edge.
Yes, and also there's of course the possibility that any Court of Appeal judgment might be so narrowly confined to the Security Services Act as at 1989 that it wouldn't actually necessarily affect the legislative framework that we have under RIPSA and so on and so forth. So there's a lot of unknowns, but as I say, I think the hard cliff edge scenario is probably unlikely.
Okay, thank you very much. No other member has indicated that they wish to ask any further questions of you on this. So thank you very much for your time and consideration on this matter today. And we will now move to agenda item 5, which is consideration of 2 negative SSIs, the Regulation of Investigatory Powers Prescription of Offices and Specification of Public Authorities Scotland Amendment Order, and the Management of Offenders Scotland Act Specification of Persons Amendment Order. And I refer members to the relevant papers in our pack. Both of these are negative instruments. Can I ask if any members have any comments that they wish to make on either of these SSIs? No member is indicating that they have any comments to make. Are members content then not to make any comments to the Parliament on either of these SSIs? Members are indicating that they are content. That concludes consideration of the SSIs. And our next item of business today is a report back on the meeting of the Justice Subcommittee on Policing that took place on the 7th of December. Again, I refer members to the relevant paper in our pack, and I invite John Finney to supplement his written report if there is anything further he wishes to add. Mr. Finney.
Thank you, Convener. I'm content with the paper. Happy to answer any questions of any member.
Thank you very much. John, do any members of the committee have questions for John about this report? No member is indicating that they have anything that they want to ask you at this point, John, so thank you very much for that. That brings the public part of our meeting to a close. Our next meeting will be a week today on Tuesday the 22nd of December, when we will continue our consideration of the Domestic Abuse Protection Scotland Bill. I now close the public part of this meeting and invite members to move into private on Teams. Thank you very much.